Please mind the gap between the train and the platform.
Thank you for tuning into Haldane's Law Matters, a podcast where we have conversations about legal developments in Hong Kong. This podcast is brought to you by Haldane's, a Hong Kong-based law firm experienced in serving the needs of clients, both in Hong Kong and throughout the Asia Pacific. Established in 1975, the lawyers of Haldane's have an extensive collective knowledge of legal practice in the region. The firm has a strong reputation across all of its practice areas, and its excellence has been acknowledged by various awards bodies.
Joining me in this episode is Anita Leung, partner at Haldane's in Hong Kong. Welcome, Anita.
Hi, Stephen.
Anita, before we start, please tell us a little bit about yourself and your practice.
I am also a partner from Haldane's, and I am specializing in doing the family law since around 2010. And then I have been engaged in day-to-day family practice, like drafting the nuptial agreements and also doing some contentious children cases and also some financial dispute matters and helping the client to resolve their disputes.
Fantastic. Well, as I said, it's great to have you on. Now, this episode, we are talking about financial issues when it comes to divorce. Financial disclosure, what is the process for this in Hong Kong?
In fact, the financial disclosure process can be quite complicated or can be in a simple way, depending on the how far the parties would like to go for the financial disclosure. If we talk about that, there is no agreement before the proceedings. Then once the proceedings started, then both parties will have to start the financial disclosure by way of filing a standard financial statement, which we call the Form E. And then this is a standard form which both parties will have to disclose all their relevant financial information. For example, their apartments, houses, the bank accounts, investment accounts. If you have some private company shareholdings, you may also have to disclose those information. Apart from your assets, you will also have to disclose your income and also the monthly expenses. But it is not just the end. You will also have to provide the relevant supporting document like the bank account statements, and also if you have your own company, you may have to provide the audited financial statements, invoices, and receipts of your living expenses. So whenever people think about the financial disclosure process in the divorce proceedings, it can become a headache to them.
Sounds quite laborious, right? I mean, it's simple, but it just sounds like so the more assets you have, the more complicated it becomes, right?
Yes, and then the process is not just limited in your Hong Kong assets. For the Hong Kong divorce proceedings, you will also have the duty to disclose your assets situated worldwide.
They really are looking under the bonnet at everything, right? When it comes to the disclosure. I recorded a few episodes before speaking to you about, on the subject of divorce, and I think the word emotional comes up quite a lot. When people get emotional, they act irrationally quite often. So when it comes to financial disclosures, we do see sometimes on the media that things are done illegally. What are the potential consequences if a spouse starts taking matters in their own hands and starts gathering information illegally about the other party on things like financials?
In fact, recently there are more cases related to this kind of conduct because sometimes when people's financial information are stored in the computer and they share a laptop at home, sometimes it may be using the other's password to get those information. The court's position on this is a bit clear. They would think that if you get some information secretly without the other's authorization to use those information, then under the law, the court will incline to give you the infringed party with an order to stop the other to using those information which obtained without your authorization. And then the court will usually order you to return those documents to the infringed party. But of course, as we have just explore how the process on the financial disclosure, because both parties will have the duty to make full and fair financial disclosure during the divorce proceedings. So even the court ordered the return of those secretly obtained information and documents from you, the court will still anticipate that you still have to make full and fair financial disclosure in your divorce proceedings upon the return of the document to you. So in any event, the party who has been obtained the information secretly by your spouse, you may expect that you will, in some extent, you will have to make disclosure related to those information properly in the divorce proceedings.
There's no point doing it secretly, no point doing it illegally, because they're going to have to disclose it anyway. Would that be a fair summary?
Yes. Of course, some people may think that if I do not do this, then the other party may just try to hide it up. But during the divorce process, when we also have some measures maybe can help our client to seek for further relevant financial information from the other party. For example, after the disclosure of the Form E, and then if you found that your spouse hasn't fully disclosed all his financial information, for example, during the marriage, you know that he has a bank account which he has not disclosed in his Form E, then you will have a right to issue a financial questionnaire on his Form E. It is a platform for you to obtain more relevant and further information from your spouse. Then you may put a question to him that whether you have a bank account with ABC Bank and why it is not disclosed, then you may still through this process trying to obtain the relevant financial information from your spouse. And because the financial process, the duty is continuing, because the court will think that the valuation of your assets will be cut off at the hearing date of your financial relief application. So it is still continuing up to the court is ready to hear the applications.
Thank you for clearing that up. What will the court take into account when considering the auxiliary relief?
When the court consider the ancillary relief, they will take into account three principles, or we say that it is the concept. The first one is the list of the parties, and then the second one is the sharing principle, and then the third one is whether there is any need for compensation. For the list one, it means that when the court first see the case, it will ascertain the total value of the family assets and the financial resources of the parties, and including the children. And then the court will also at the same time consider what is the reasonable financial list of both parties and the children. If the total family assets is more than the financial list of all parties, then the court may then consider to share the family capital accrued during the marriage between the spouse. And then in that case, sometimes the court will take into account a number of factors. For example, the duration of the marriage, the age of the parties, the potential future earning capacity of the parties, whether there is any physical or mental incapacity of either the party who will have more financial risk in the future, and then also the contribution from both parties. For the contribution, it is not just mean the financial contribution from the parties. For example, usually in some families, one party may go out to work and earn the financial resources for the company, and the other party may stay home as a stay-home mother or father to take care of the needs of the children. In that case, in Hong Kong, our law will consider both kind of contribution as important contribution to the family. And this will also take into account when consider the level of capital division and future maintenance to the other spouse. But of course, if the total family assets is insufficient to cover the financial needs of the children and the other financial relying spouse, then the court may not be able to just divide the assets between you two and have a clean break settlement, but the court may have to order an ongoing monthly maintenance to the spouse so that her financial needs will be, her or his financial needs will be cared of.
It does sound like when it comes to divorce, there's a lot of complicated decisions that courts have to make on this.
Yes. So we will always say that the court will consider on case-by-case basis, because there is a factual matrix of each case, and those factors relevant to the cases will be taken care of by the court, and each factor may carrying different weights in each case. So that's why sometimes the court will have to first see all the financial information of the parties before they can consider what level of capital division and financial maintenance will be given to the parties.
Right. And to work out those metrics, do the law firms get involved with that, or is it done independently by the courts?
Usually, we will assist the client to analyze the financial data, because during the process, sometimes after they make the disclosure through the Form E, then we can help them to take a look and do the analysis on the financial resources of the family and their financial needs. And then we can use our experience to advise them on the likely outcome the court will provide for them at the trial, so that we can help them to have some reference in the negotiation on the settlement with the other party. And hopefully both parties can work out a settlement offer, then we can explore a settlement before both parties have to go for a full trial. And this is, I think it is the main role of your divorce lawyer will help you during the process. Because sometimes the court may advise the parties to try to have some negotiation or attend the mediation to try for a settlement arrive between the parties. Then we will help them to look at the financial disclosure, sometimes by way of the proper Form E, and then sometimes if they don't want to go through that complicated financial disclosure process, then before they involve the court, they may do some voluntary disclosure between themselves. Then they can try to explore a settlement with the advice from the lawyers to reach a settlement during the negotiation or mediation sessions.
Thank you, Anita. That's all the time we have for this episode. So, Anita, thank you very much for your time today.
My pleasure. Thank you, Stephen.
And thank you, listeners, for listening. I look forward to talking to you on our next episode.
請勿靠近車門，請不要靠近車門。Please stand back from the doors.
Thank you again for tuning in. And to find out more about Haldanes, please visit www.haldanes.com.